and Bogolyubov and others.
Yes, Mr.
Yes. May it please your Lords, I appear together with my learned friends, Mr. Milner and Mr. Kuhn, and will be making submissions on behalf of the appellants, Mr. Kolomoisky and Mr. Bogolyubov. Mr. Hunter, Mr. Sewell, and Mr. Lloyd appear for the respondent Privatbank, who I shall refer to as the bank. The appeal is brought by both appellants, permission having been refused by the judge but granted by Lord Justice Lewison on the 9th of January 2026, and it's against the judge's findings which resulted in the principal judgment for, in round figures, $1.7 billion in damages and $1.2 billion in interest. As your Lordships know, the bank is a large, now state-owned Ukrainian bank, having been nationalised at the end of 2016. The defendants are, the appellants are Ukrainian nationals, neither of whom is domiciled here. They were formerly the owners of in excess of 80% of the bank, and the claim concerns their conduct as owners. Essentially, the complaint is that they improperly misused the bank's funds. Now, it's clear on the basis of the judge's findings and various pronouncements by the bank that it could have claimed against the defendants following the nationalisation for a sum in excess of $5.5 billion, because that was the black hole left in the bank's finances said to have been created by their misconduct. But bearing in mind the bank is Ukrainian, the defendants are Ukrainian, the conduct complained of took place in Ukraine, and any claims are governed by Ukrainian law, any such claim self-evidently would have to have been brought in Ukraine. For reasons which have never been explained, however, the bank was averse to suing in its home state. To the contrary, it was determined to sue here, no doubt perceiving some advantages in doing so. Accordingly, it sought to identify a claim for which it could establish an English hook to allow it to sue here. And so what it decided to do was to focus on a specific set of what have been called drawdowns procured by the defendants between 2013 and 14. And your Lordships will have seen they're called in the litigation the, quotes, relevant drawdowns, quotes. The advantage of suing on the relevant drawdowns was that they involved or could be related to claims that could be brought against 3 English companies or suppliers in unjust enrichment, so that it would be expedient for the claims against the defendants to be tried together with the claims against the 3 English companies. In other words, the claims in unjust enrichment against the 3 English companies provided the hook for English jurisdiction against the defendants. One difficulty with that approach, however, was evident from the outset, and it was this. As is common ground, the bank's books and records evidence that the relevant drawdowns had, in all but 2 cases, been fully repaid. The question is whether that is of any significance in relation to the claim in tort which the bank brought against the defendants for having wrongfully procured the relevant drawdowns. In other words, could the bank maintain its claim to loss in respect of the relevant drawdowns, notwithstanding the evidence that they had been repaid and have at all times been treated by the bank in its records as having been repaid? Now, the learned judge held that it could, and that the evidence of repayment was not fatal to the bank's claim. We say that he was wrong so to hold, and accordingly he should have held that the claim failed, save in respect of the 2 relevant drawdowns that had not been repaid. So, my lords, the issue on the appeal is therefore whether the judge was wrong to hold that the bank was entitled to be compensated for losses arising from this series of tortiously procured relevant drawdowns, or whether he should have held there was no loss to compensate because they had been repaid. Now, we submit that the judge went wrong in 2 distinct respects. But first, there is a measure of common ground between the parties in that we agree that the appeal turns fundamentally on two questions, although, as I will seek to show, the questions are often muddled in the judgment. The first question is this: if a tortiously procured drawdown is repaid using money derived from another tortiously procured drawdown, does that extinguish pro tanto the loss arising from the first drawdown? And my lords, that is a question of Ukrainian law. The judge found, summarizing it, that as a matter of Ukrainian law, repayment of the first drawdown would extinguish the loss if the first drawdown was made under a valid loan, but would not do so if the first drawdown was made under a void loan. We will submit that this distinction and conclusion make no sense in principle, and unsurprisingly wasn't supported by any kind of Ukrainian law source or authority. And we also say there was no proper evidential basis for it, and the judge was wrong to accept it as representing Ukrainian law. So that's, as it were, the Ukrainian legal question. The second question is whether the relevant drawdowns that the bank chose to sue upon were in fact repaid so as to extinguish, if we're right on the first point, the tortious loss. Now, that is a question of fact, the question specifically being whether the bank chose to accept repayments as reducing the liabilities of the companies that received the drawdowns. Now, unfortunately, as it seems to us, the judge never actually answered that question. Instead, he misunderstood the case being made, and it was specifically being made by me on behalf of Mr. Kolomoisky at that stage, and asked himself a different question, which was whether the bank had chosen to accept the payments as reducing the tortious loss. In other words, whether it had deliberately waived its tortious claims. We submit that if he had asked himself simply the correct and more straightforward question of whether the relevant drawdowns had been repaid, he would have had to conclude that they had. Alternatively, if he did address that question and answered it in the negative, we say that finding was perverse and not one he was entitled to reach on the evidence. Now, my lords, in order to demonstrate why the judge went wrong and to develop my submissions, I'm going to deal with it under 8 headings or chapters. The first is I will introduce the issue and explain why it arises. I've touched on that. I'll expand a little bit. The second point is I will outline the essential facts which can be taken from the judgment, in particular the mechanisms by which the various drawdowns were made and then repaid. Third, I'm going to focus on what have been called in the litigation the cash repayments, which involve bank transfers to transmit money, and to identify the correct analysis of the situation where a loss is remedied using the proceeds of a further tort. Under this heading, I will explore that question as a matter of principle and by reference to English case law, which is instructive for a number of reasons, although the claim is ultimately governed by Ukrainian law. And just to anticipate that, as you will see, the Ukrainian experts referred to the English authorities and said Ukrainian law would be the same. And the fourth heading is I will take you to the Ukrainian law materials themselves, first in the written evidence and then the oral evidence of Mr. Beketov, the bank's expert at the trial, which we'll see his oral evidence was markedly different from his written evidence. In our submission was not a remotely sufficient basis for the judge's conclusion on the central issue concerning repayment. Fifthly, I will briefly address the legal principles in relation to appeals on foreign law, but I apprehend that the court is very familiar with those. Sixth, I will then apply the principles to the judgment in this case and explain why the judge was wrong to find, in relation to the first of the two issues I outlined, that cash repayments would not extinguish the loss, and why the court should have no hesitation in saying so. Seventh, I will seek to make good the fact that cash repayments did take place and were not just quotes, recorded quotes as having taken place, as the judge said, whatever that terminology is intended to mean. And eighth and last, I will address the asset transfers and to explain why a similar analysis should apply to those as to the cash repayments with the same result. So, my lords, with that introduction, I turn to the first point, how and why the issue regarding repayment arises. Now, I've already explained that the Ukrainian context and the choice that was made to sue here, it is worth just noting that there was absolutely no impediment to the bank bringing proceedings in Ukraine. Now, as I said earlier, it may be the bank was determined to pursue the claim for tactical advantages. It may be it wanted the advantages of a worldwide freezing order and asset disclosure, or it may be that it preferred its Ukrainian law claims not to be scrutinized in Ukraine. I don't know. But what I do know is it was determined to sue here, and so to do that, it sued three worthless English shell companies as anchor defendants. And the real defendants, Mr. Kolomoisky and Mr. Bogolyubov, were then joined as additional parties under Article 6 of the Lugano Convention. So the bank was able to bring its claim here, but in order to do that and to sue on that basis, it had to base and deliberately based its claim on and only on a specific set of drawdowns which found their way to the English companies.
It doesn't matter. You refer to Article 6 of Lugano. I'm puzzled by that because the United Kingdom is not party to the Lugano.
No, at the time when the proceed... Sorry. What did you say? Yeah, the proceedings were commenced in 2018.
Right.
And so at that stage...
All right. As I say, it doesn't matter.
No, I mean, we had a battle on this that went up to the Court of Appeal. But at first instance, it was found that on various reasons, that the English court didn't have jurisdiction, and then the Court of Appeal interpreted the Lugano Convention more broadly. None of that, it's all of historical interest, because obviously we're not party to it now.
Thank you.
But, my lord, as I said, the difficulty with the drawdowns they sued on, that other than two, and I'll just for your note tell you the two, there were two. One is to a company called, or the loan was in the name of a company called Tamersa, which was for $19 million, or the amount of the drawdown, and the other was a company called Prominmet, which was in Ukrainian hryvnia of 433.9 million. Now, the bank had to come up with an explanation of how it could sue on the particular drawdowns, the relevant drawdowns, even though, according to its own records, in all but two cases, they had been repaid. Now, the difficulty was accurately, or the judge accurately described what we said, was there was a self-imposed straitjacket which they were required to wear by reason of the forum shopping in which they'd chosen to engage. The judge references that at paragraph 32. Now, I just want to sort of focus on how odd this is for a moment, and peculiar and artificial. If one imagines a normal situation where a defendant commits two torts, it could be any number, but let's keep it simple with two, and he uses the proceeds of the second tort to repay the loss caused by the first tort. The claimant, you would expect, would either sue for the loss arising from the second tort, the money that's taken then, or it would sue on the basis of the whole scheme and recover the overall loss which it's left with at the end of the day. And of course, if the loss from the earlier tort had been remedied in full, in economic terms, it makes no difference which way you formulate the claim, because in either event, the loss exists at the time of the claim, and the loss is the loss resulting from the second tort. The loss from the first tort has been extinguished. Now, we say that's the case in English law, although my learned friends now dispute that, and we'll have a look at that. But how did they get there for these proceedings? From the outset, they relied on what was said, and they relied exclusively on what was said to be a rule of Ukrainian law, whereby, as the Court of Appeal put it in its judgment, we don't need to turn it up, but it's paragraph 230 in Authorities at page 1279, a purported repayment of a relevant loan can be disregarded if the repayment was made with funds derived from another fraudulent loan. Now, in order to actually understand what the point is, can I ask you, or how it arose, can I ask you to go to the supplementary bundle, please, at page 276. And this is an extract from the fifth expert report, you can see it at page 275, of Mr. Beketov in July 18, in other words, at the commencement of the proceedings. And at paragraph 15, he explains the position where he says, moreover, in general, I consider that where money is purportedly used to repay an unlawful loan, see, he uses the term unlawful, note that, are themselves referable to other unlawful lending, as a matter of Ukrainian law, the repayment would not be considered to operate to reduce the bank's loss. And then he says in his first report, he explained why the reduction in outstanding liability on the relevant loans using monies referable to subsequent unlawful loans did not operate to reduce the loss. So he's saying, even though there's been a reduction in liability on the relevant loans, that didn't reduce the loss. And in my view, the same applies in respect of any reduction in outstanding liability on the relevant loans using monies referable to prior unlawful loans. So what you see, quite important to just understand very clearly what the issue is. What he's saying is, for the purposes of a claim in tort on the relevant loans, if the relevant loan has been repaid using monies referable to other unlawful lending, then that doesn't affect, notwithstanding the reduction in liability, it doesn't affect liability on the relevant loan, doesn't affect the tortious loss. So that's how things stood in the Court of Appeal. And the Court of Appeal accepted, at that stage, this hadn't been interrogated, that was an arguable position. So what does this all amount to? The proposition per Mr. Beketov was that where you had two wrongful or unlawful, as he put it, drawdowns of, let's say, $100 to borrowers A and B, and notwithstanding $100 is paid back to the bank and credited to the drawdown advanced to borrower A, the bank can sue the person who procured the drawdown just in relation to the advance to borrower A and recover its net loss from both transactions. And you see that's exactly what Mr. Hunter explained to the Court of Appeal at paragraph 231 of the judgment. Now, we interrogated this at the trial, and we say the principle is wrong and the judge was wrong to accept it. Now, my lords, it is important just to emphasise as an introductory point that this is not a case where the defendant's position is somehow unattractive or counterintuitive. It doesn't imply that somehow the defendants have pulled off the perfect fraud where there's a loss to the bank but no liability. To the contrary, on the basis of the facts as found by the learned judge, the bank had a claim, and indeed on the judge's findings, an unanswerable claim to recover the loss it was left with at the time the proceedings were started, and indeed for a far larger sum. But that claim was one that had to be brought in Ukraine. The difficulty has arisen because of this attempt to sue in England, which has forced it to confine its claim in a highly artificial way to a particular group of historic drawdowns, almost all of which had been repaid, and to develop, for the purposes of this case, and I stress that, to develop for the purposes of this case, a theory of Ukrainian law that allowed such an odd-looking claim to be brought. So, my lords, there's no injustice to the bank if that theory is rejected. It's simply the consequence of their having brought this contrived and artificial claim in an unnatural jurisdiction, having stretched the Lugano Convention to its limits in pursuit of a collateral advantage. Now, my lords, let me... we suggest that the court should not be in any way troubled by this because, as I say, firstly, this is a consequence of the way the bank has chosen to proceed. And indeed, what should be, would be more troubling is leaving the matter as it is, because in our suggested submission, what the learned judge has done is both contrary to logic and principle, and indeed potentially has an impact on English law because, as I'll show you, although this case is a Ukrainian law case, what was being applied were the same as principles in English law, and indeed the judge, we suggest, was departing from the principles that you find in the English law cases. My lord, with that, I'll move to the second point, which is the facts. The purpose of doing this is just to highlight to your lordships how the question arose. So taking the judgment, your lordships will see that the relevant loans are described at page of the core bundle 213, paragraph beginning at 315. So in that section, the judge explains, you start off with relevant loans, and that's in this section that goes to 335. They were revolving credit facilities entered into with 50 borrowers between April 13 and August 14. Now, my lord, it's now, at this stage of the case, common ground they were void, but in form, at least, they were loan agreements. Now, having entered into or purported to enter into the relevant loan agreements, the bank then advanced money to the borrowers by what are called the relevant drawdowns. They're addressed in the judgment at 373 onwards. And the relevant drawdowns, as I've explained, are what it's the loss purportedly or allegedly on those is on which the bank sues. At 374, the judge explains there were 270 relevant drawdowns between November the 1st, 13 and 1st of September 14 for in round terms, $1.5 billion and 8.8 billion Ukrainian hryvnia. Now, those sums were then, which were drawn down to the borrowers, were then transferred to other companies, including the English corporate defendants, ostensibly as prepayments for various goods under supply agreements. Now, in fact, the supply agreements were shams, and there was never any intention that any goods would be supplied to them. So the supply agreements were simply mechanisms for moving money, particularly foreign currency, out of the bank and out of Ukraine, or for other uses in Ukraine, whether it was out of Ukraine. Now, initially, the prepayments were returned by the suppliers or purported suppliers to the borrowers. So what was going on was what your lordships be familiar, a form of loan recycling scheme. After August 2014, the suppliers stopped returning the prepayments. And in total, around $1.9 billion that was withdrawn from the bank and used to make prepayments was not returned by the suppliers to the borrowers and then to the bank, as the judgment records at paragraph 380. Now, before I explain what happened next, two points I'd like to address. First, although it's fair to say this wasn't part of the evidence that was examined at the trial, there was no dispute that this pattern of drawdowns under loan agreements used to fund so-called prepayments didn't start from scratch in April 2013. It was the continuation of an ongoing process of recycling of loans and prepayments. The judge references this at 398 on page 232 in the second sentence, where he says the bank didn't dispute there was or may have been other improper loan recycling prior to April 2013. Now, that's just by way of background. Nothing turns on it. Secondly, although the relevant loans and supply agreements were all found by the judge to be void, that should not obscure the fact that payments by the bank to the borrowers and by the borrowers to the suppliers, and payments in the opposite direction when they occurred, were all actual payments involving real movements of money between the parties involved. Now, my lords, it's particularly important to be clear about this, because we will later have to address the question of the repayments and what their effect was. But whatever their effect was, all the payments and repayments involved real movements of money from the bank to the borrowers and back again. The transactions under which payments and repayments were made may have been void, but money nevertheless moved from the bank to the accounts of the borrowers and on to the suppliers. And for instance, the judge explains this at 376 at page 227.
When you say money, you don't mean gold coins, you don't mean cash, you mean entries in bank accounts.
I mean, but it is entries in the bank account, credits and debits, but those, and as the Ukrainian expert said, that involves real movements of, it's a real credit to somebody, they then have the money. It's obviously not gold coins, as your lordship says, but it is, they don't physically have money, but they have effectively a shows in action. They have a right, and so...
I don't think it arises on the appeal. I think there's any dispute between you on the appeal. But
Yeah.
I have a difficulty with this because, as you say, we know that money in a bank account is a shows in action. It's not cash. It's a right to sue the bank. If you have a bank account which shows you as being in credit to tune of $100 million, that means the bank owes you $100 million.
Yes.
But if the loan is void, the bank doesn't owe you $100 million.
Well,
so although the piece of paper, your bank statement shows it as owing you money, in what sense do you really have a claim against the bank? You don't really have a claim against the bank.
Can I just show you first what the judge says? Because, of course, there is a sort of philosophical issue, which your lordship is right about, which could go to a question as to whether the bank ever suffered a loss at all.
Well, I think that was a point taken not by Mr. Kolomoisky, but by Mr. Bogolyubov.
Yeah, I have the same difficulty.
But the judge rejected it, and it's not revived on this appeal. It seems now to be common ground that the harm takes place when the drawdowns take place.
Yes.
Even though the drawdown, as I say, doesn't consist of people bringing cartloads of coin. It consists of entries in.
That's right. But the judge accepted the Ukrainian lawyer's analysis. Let me just. It's not actually the paragraph I was going to show you. What is
I don't want to take you out of course.
Not at all.
But at some point, I would like to understand in what sense it's now accepted that the bank suffers a real loss when people are credited in their bank accounts with money.
Yeah, my lord, if you go to page 357 in the judgment,
Thank you.
at the paragraph 903, which is dealing with the question of harm, and in the second sentence, it was common ground between the experts that money in the form of cash or in a bank account is a form of property for these purposes, and the loss of money is capable of amounting to harm for the purposes of a claim. As Mr. Beketov explained, an electronic transfer of funds from one person to another is thus capable of constituting harm. And so there's another. Sorry, 905. Yeah. Yeah, 905, the experts agreed, or 904, it was also common ground that where a person commits an unlawful act involving a deprivation of property, harm is suffered, and so on. And the experts agreed this principle works in the present context, is that if a person receives money pursuant to an invalid and unlawful loan agreement, the payer will be caused harm by the person who acts unlawfully in obtaining it. And if your lordships read on to 906.
So, as I say, it seems to be, and this is not appeal, it seems to be common ground that in this case deprivation occurs when the drawdown takes place.
Yes.
Even though when the drawdown takes place, all that actually happens is entries are made in the borrower's bank accounts, which, as you accept, gives rise to a shows in action. If the shows in action is void, I don't myself understand why the bank's lost any money at that point at all. But
well, because what the Ukrainian lawyers said, I'll come back to it, is that once that credit is made to the bank account, the recipient is entitled to deal with it as he pleases, even though it was pursuant to a void transaction. So it becomes his property. And so the Ukrainian lawyers, we might not see it in that way, but the Ukrainian lawyers certainly saw it in that way.
okay, thank you.
The paragraph I was going to go to is at 376. And we'll come back to my Lord Justice Nugee's point perhaps later. But at 376, the judge explains the flow of funds where a relevant drawdown was made in a hryvnia, it's converted to dollars. The dollar proceeds of each drawdown were then transferred to the account of one of the suppliers amongst which were the corporate defendants at the bank's Cyprus branch, and then the transactional data recorded this, and so on. Now, perhaps for present purposes, what is simple to say is that what it is that is said to create the harm, which is the drawdown to the borrower, in other words, that is a movement of, it's certainly a movement in the books, but it's treated as the borrower receiving the money, and that the bank at that stage suffers a loss. Conversely, the same thing is happening when the payments back are made, which we say gave rise to the repayments. I'm going to come back to this in more detail, but that just at the moment I'm just showing your lordship what happened with the relevant loans. So you had these drawdowns, which the judge found caused loss. Now your lordships may have seen there's also reference to, just to make it more complicated, to intermediary loans. That's at 406 at page 234. This is, you can see it's headed cash repayments in the intermediary loans. And what the judge explains at 409 or 406, that he explains that in the first sentence, he explained our case was that the relevant loans had been repaid from a number of sources. So the first source was cash, substantially all of which came from intermediary drawdowns made under both relevant loans and further intermediary loans, and 34 to the borrowers and 34 further Ukrainian borrowers, which is described as the intermediary lawyers. They were agreed during what the bank calls the active stage of the misappropriation. The second source is asset transfers. The third source is new loans. So at the moment we're focusing on intermediary loans, and for present purposes, as the judge says, some of what are called some of the repayments come from other relevant loans, and some come from intermediary loans, and essentially these were just other means under the scheme whereby relevant loans were repaid, sometimes out of other relevant loans, sometimes out of intermediary loans. Now again, these intermediary loans were no different in the way they operated to the relevant loans. So that, as the judge says, was the position until 2016. In 2016, towards the end of 2016, the National Bank of Ukraine had previously published a report in, I think, December 15, requiring a recapitalization program and restructuring. The judge describes that at 485 and following. And it was in that context that the asset transfers occurred. In short, those involved, Mr. Kolomoisky and Mr. Bogolyubov, transferring or procuring the transfer of pledged assets to the bank with an agreed value, and the bank then crediting the relevant loan accounts with the agreed values. Now, that restructuring plan was not successful, and it was eventually decided that the bank should be nationalized, with the existing bad loans being replaced with new loans to other companies controlled by the defendants, which were intended to be solvent and able to repay the debt and backed by adequate security. That process was known as transformation and is described in the judgment at 536 and following. And as you've seen already referenced at 406, new loans were issued with a total value of in excess of $5 billion to some 36 new borrowers in October and November 2016. Now, the new loans were used to cover the debts of some 193 borrowers, not just the 50 borrowers who had entered into the relevant loans. And what happened was the $5 billion was paid to the accounts of the 36 new borrowers and then used to pay off the loans of the 193 borrowers. And as the judge says at 554, the bank's books recorded the existing loans being closed out, having been repaid with the proceeds of the new loans. Now, in the event, the new borrowers were no more creditworthy than the earlier 193 borrowers. Now, at 554, one has one of the places in the judgment where one finds the judge describing the payments that occurred, which constituted the repayments, in equivocal language, referring to what was recorded as having happened rather than what actually happened. So you see at 558, he says that furthermore the bank does not accept that the transactions recorded in its books reflected the true legal consequences of what had occurred. It submitted that the making of the new loans and the application of their proceeds in the manner I have described did not amount to a genuine repayment of the debt owed by the 193 borrowers, and more specifically, any amounts in respect of the relevant loans. There he's recording what the bank was saying. Now, there was a dispute, and this is important to keep in one's mind. There was a dispute before the judge, which is no longer live, as to whether any of the loans pursuant to which the relevant drawdowns were made were valid or not. Now, if the relevant loans were void, as the judge found and is now common ground, then plainly the repayments, or the payment of money pursuant to such a loan, was not a repayment of a loan as such, because there wasn't one. And to that extent, it's legitimate to distinguish between what was recorded or purported repayments of loans and what actually happened. But again, what cannot be disputed is that there were real movements in the account from the bank to the new borrowers and from the new borrowers back to the bank. Can I show you supplementary bundle 300, page 304 for a moment, which is an extract from the expert report of Mr. Thompson, who was the accountant, the forensic accountant, giving evidence on behalf of the bank. And what he does is helpfully illustrate how repayment occurred via the process of transformation. And you can see in the text on that page, he says at A1 that the repayment of relevant and intermediary loans is considered in his report. Next paragraph explains how many relevant drawdowns were repaid directly and what he calls indirectly via transformation. But he gives a figure, it's page, he gives a diagram which explains what happens. So you see in the bank box, new loan, drawdown of new loan.
Very sorry, but I'm struggling to find this page.
I'm sorry.
Supplementary bundle on page 304.
Yes.
My supplementary bundle ends at 303.
This is an additional page that we've added in. I don't apologise for that.
It doesn't seem to have found its way in.
No. Okay. Well, can we make it good? At the moment, if you can just take it from me, that he has a a diagram which explains that what happens is you get a drawdown of a new loan, proceeds go to new borrower, that goes to the old borrower or the borrower under the relevant loan and recorded as them repaying the relevant loan. Now, this and what we simply say about this is that if the transactional data was correct to record the outflow of money to the original borrowers and to the new borrowers, it must equally have been correct to record the receipt of money by the original borrowers from the new borrowers and from the original borrowers to the bank. In other words, the simple point is you can't treat the various sets of entries differently. The outflows and inflows all have to be treated consistently. And this goes to the bank's fundamental answer to the appeal, which it calls the borrower discharge premise. And the argument is that the recorded repayments never discharged the borrower's liabilities to repay the relevant drawdowns. And the additional argument that it's not even open to us to argue there was a repayment on that basis. Now, I'll come back to that more fully in a moment, but the fundamental argument we suggest is wrong once it's recognized that relevant drawdowns and the prepayments involved actual movements of money to borrowers, creating liabilities to repay on behalf of the borrowers. It necessarily also follows that the intermediary drawdowns and the new loans also involved movements of money in the opposite direction. Now, they may not have been, none of this may not have been, indeed it wasn't, payments and repayments of contractual debt. But payments and repayments they nevertheless were. And of course, there were liabilities, as the experts said, in restitution. There were restitutionary debts, not contractual debts. Now, my lord, none of this is affected by the fact that the ultimate source of repayments was further drawdowns from the bank. And the bank it's a fair point that the bank can make, and it does make in its skeleton argument at paragraph 19, that the overall effect of the transactions was circular, with money going from the bank to the new borrower, to the relevant borrower, and back to the bank. So it's fair to say that none of this involves new or additional funds being paid in, if you look at the universe of the bank as a whole. Now, all of that may or may not be relevant when we come to assess the question of tortious loss. We say it's not relevant to that, but it's not relevant to the question whether actual payments and repayments were made at all. And my lord, just to give you an aide-memoire, if you go in the supplementary bundle to page 280, no, it's the wrong reference. Where's the expert? Yeah, no, supplementary bundle, page 284. You should have an extract from Mr. Thompson's report, just so your lordships have firmly in mind how all of this works. So you can see that if we just focus on the US dollars, that there was 2.17 billion in total drawdowns, and the repayments are 2.15 billion. The difference, if you look at note 1, is because of the two that I told you about that hadn't been repaid to Mercer and Prominmet. And then you can see the mechanisms by which the repayments are recorded in the books is cash repayment of 1.5 just under 1.2 billion, asset transfer of 551 million, and transformation of 405. That's the new loans. Now, there was a separate exercise, and that was a summary of our case, but Mr. Thompson accepted that, and you see that at page 286 at paragraph 417, 4.17, I beg your pardon, in the second sentence, he accepted that they were able to verify the information set out to the bank's transactional data. Now, Mr. Thompson did a further exercise whereby he sought to analyse the ultimate source of repayment. Now, on our case, that's not relevant, although on the bank's approach, that kind of analysis is necessary because you trace back through repayments of repayments of repayments in order to determine whether the ultimate source was something referable to wrongdoing against the bank. And my Lord, can I then turn to my third heading, which is the analysis of repayments, both as a matter of principle and as a matter of English law. And it was common ground at the trial that there are no Ukrainian cases or commentaries addressing the question as a matter of Ukrainian law. Now, you might say that's unsurprising because in the sort of circumstance with which we're dealing, you would expect the victim of the wrongdoing either to sue for the loss on the second tort or to sue on the entirety of the wrongful conduct, claiming for the loss at the end. You wouldn't expect them to sue only, as it were, on the first tort. Now, although there are no Ukrainian cases, the issue has been considered in two particular English cases. Those are relevant, firstly, because English law provides a useful reference point, but secondly, the Ukrainian experts actually relied on this English case law, in particular a decision called Yurov. And the Yurov case was in fact not a case decided under English law, but it was decided under the Russian Civil Code, Article 1064, the terms of which are the same as Article 1166 of the Ukrainian Code. Now, Mr. Beketov took into account the English case law in the context of what was called the use of funds defence. But the judge and Mr. Beketov failed to go on and draw the appropriate conclusion from those cases for the repayment defence. Now, can I take you to the first one, which is in the Authorities tab 12, which is the Kolomoisky banker case, a decision of Mr. Justice Torson, as he then was, in 2002. And this was a claim against a company, quite an infamous company, I think, in the annals of English litigation, called Stone and Rolls, and its controller and CEO, Mr. Stoyevich. The claim was about a fraudulent scheme involving letters of credit. The CEO had fraudulently procured the bank to issue a series of letters of credit. Some were issued in favour of Stone and Rolls at the request of another company called BCL Trading. If your lordships look at page 464, paragraphs 1 to 8 summarise the position. You can see at paragraph, as you would expect, the LCs were payable against documents, and 6 explains that there were no genuine underlying sales of produce, the invoices and other documents were sham, and Stone and Rolls acted as BCL's puppet and accomplice in a dishonest scheme designed to obtain money from it by false pretenses. And at 8, it's explained that the claim was brought in deceit. Now, the relevance of the case for our purposes is, so you had these drawdowns under the letters of credit, and the argument that was being made was that the bank should give credit to the extent that the proceeds of the letters of credit had been paid back to the bank to discharge pre-existing liabilities. That's not what we're concerned with now, but that's the defence known as the use of funds defence. And if you go to page 492 of the bundle, paragraph 158 of the judgment, you can see his lordship explained that at 158 that the defendants contend that the bank received benefits as a result of the LC transactions for which credit should be given to the extent that sums derived from the proceeds of discounting were used to discharge liabilities of DCL or connected companies to the bank. And then at 161, his lordship gives examples of 2 types of transaction. So if you look at the first one, payment of $3.9 million to SR Prague, he explains that on the 4th of August, SR paid $3.9 million to an account held with the Claimant Bank. It's an example of recycling of funds obtained from discounting of LCs. On the 6th of August, $3.9 million is transferred from SR Prague to DCL's account. Before the 1st of August, the balance of DCL account was $5.6 million. On the 1st and 3rd of August, the bank reimbursed itself from the DCL account in respect of 3 matured LCs, one of which had been issued in favour of SR. Total amount deducted by the bank from the DCL account was $8.4 million, and the balance of the account, after it had been credited with $3.9 million, was just over $1 million. And then applying a first in and out approach to the transactions, the defendants say that approximately 2.8 million of the 3.9 million transferred from the SR account from 6th of August was used to discharge BCL's liabilities to Commercini Bank in respect of the LCs for which the bank reimbursed itself. The bank doesn't accept this approach as appropriate. So, in other words, what you've got is a fraudulent drawdown under the second letter of credit, and the bank is then repaid in respect of a fraudulent drawdown under the first letter of credit. And what the defendants are saying is, I haven't caused you loss to the extent to which the drawdown was used to repay an earlier existing liability. Now, at 163, the judge explains the argument. He says the defendants accept they cannot claim a benefit in the form of the discharge of indebtedness of DCL in circumstances where SR has already had the benefit by a reduction of SR's own liability to the bank, i.e. where an LC issued in favour of SR was reimbursed out of a later LC. However, in the case of the first example given above, 2 of the LCs in respect of which the bank reimbursed itself from the proceeds of the money paid by SR to DCL had been issued in favour of other beneficiaries. It's argued that since it was SR's money that discharged the reimbursement obligation in respect of non-SR LCs, the bank should give credit for the benefit to itself of that reimbursement in the calculation of its claim against SR, because SR's payment conferred on the bank a benefit which it would not otherwise have enjoyed. Now, if you go to 165, the judge then deals with this, and the important paragraphs are 168, the important paragraph for present purposes is 168. It's necessary in each case to identify the relevant venture or transaction. In the present case, there were a considerable number of them. Each time the bank accepted fraudulently presented documents, it accepted liability under a separate LC. But with that liability went the benefit of a right to reimbursement by DCL. And it's the next sentence which is important. If the bank received such reimbursement from or on behalf of DCL, that would extinguish the bank's loss in respect of that transaction, whatever the derivation of the funds may have been. So if the proceeds of LC number 2 were used to reimburse the bank in respect of LC number 1, that would extinguish the bank's loss in respect of LC number 1. In this regard, the identity of the beneficiaries under the LCs is immaterial. Conversely, if the bank did not receive such reimbursement in respect of LC number 2, its loss in respect of that LC remains. The fact that the proceeds of LC number 2 may have been used to reimburse the bank in respect of LC number 1 is, in my view, irrelevant to the bank's claim in respect of LC number 2. So what the judge is saying is that where LC number 2 was used to repay LC number 1, that discharged any and extinguished any, discharged any loss or extinguished any loss in respect of LC number 1, but the claim remained for loss in respect of LC number 2. In other words, as the point he emphasized, what matters is whether the liability arising from the transaction, which is the subject matter of the claim, has been reimbursed. If it has, the loss from that transaction is extinguished, or at least reduced pro tanto. Now, in that case, the letters of credit were payable against various documents relating to sales. There were no genuine sales. The documents produced were shams as part of a scheme to obtain money by false pretenses. In other words, the defendants had committed a tort in procuring the production of the documents and the payments. But if the bank was reimbursed in respect of a transaction, call it the first letter of credit, by a fraudulent drawdown on a second letter of credit, the loss in respect of the procuring of the first letter of credit was extinguished, albeit that the bank could sue for damages in relation to the procuring of the second. What it could not do, on the judge's approach here, would be sue for loss in respect of the first. Now, at 171, I mean, I won't read it out, but I invite your lordships to read 171, where he amplifies the point. Right, perhaps it is worth drawing it, because it's actually similar to our position. Consider the next position: if the fraudster decides to use the proceeds of his fraud to discharge a liability owed to the bank by a third party, I reject the argument he would be entitled to have that taken into account as a relevant benefit to the bank when calculating the loss. As before, his use of the funds would be the result of his independent choice how to use the opportunity created by his fraud. Just as it would be wrong a customer who could not repay his overdraft should be able to pay off the overdraft with funds obtained from the bank by deceit, and then defeat the bank's claim for deceit by saying there had been no loss from his deceit, since the money obtained from it had been used to repay a debt that he could not otherwise have paid, so it would be wrong that a similar result should be achieved by a customer and accomplice, as would be if the accomplice were able to obtain money from the bank by fraud, use it to discharge the customer's indebtedness, and then defeat the bank's action in deceit by the plea there had been no loss. And at 172, he considers a similar point. Now, so in our submission, there's no doubt that under English law, where a fraudster uses the proceeds of a fraud to pay off an earlier liability owed to the claimant, he's not entitled to say that the claimant has suffered no loss by reason of his later fraud because of that. But the reverse is not true. The loss connected with the earlier liability which is paid off is extinguished. Indeed, that's the point that Mr. Justice Tolson explains at 168. The claimant has his claim in respect of the later fraud if he chooses to bring it. Here, the bank chose not to do that, at least not here. And at 175 to 6, his lordship explained what he regarded as the policy behind it. Now, this case was cited and relied on in the case I've already adverted to, Yurov, which is in Authorities 36, tab 36, at page 1294. It actually is a very long judgment of Mr. Justice Brimes, but the bit that we're interested in is at page 1668. It was a case involving, another case involving a fraudulent loan recycling scheme. Claim was brought against individuals who procured the loans, and they ran a use of funds defence, arguing that the loans were the subject of the claim had been used to refinance other loans, which would otherwise not have been repaid. Now, you can see an explanation if you go to the beginning of the judgment at page 1297, at paragraphs 1 to 2. Just for your lordship's note, explains the context in which it arose, and your lordships will see a number of similarities to this case in the nature of the case. But if we go then to 1668, there is a section, which is section N.2.5, called the deferred loss point, and this is where the judge addressed the use of funds defence, and it starts at 1187, and you see the deferred loss point has a basic factual premise as posited by the shareholders. Paragraph 138 of the opening supposes the bank is owed $1,000 by borrower X, but that debt is a bad one, and a similar point made in the other skeleton. And at 1188, the judge says the underlying factual premise that must then be applied and proved is there is an existing bad debt, i.e. one of which no repayment will be made. And he says that they fail because they didn't actually establish that. So, but at 1192, he says that in any event, despite their failure to prove the facts, he says in the second line, even more fundamental difficulty with it, and that is that such an approach is wrong in principle in the context of lending, which was itself not in the best interest of the bank, involved the commission of offences and was in bad faith, with the shareholders breaching their duties to the bank in procuring such loans. And at 1193, he says, as the bank points out, the shareholders' argument involves the acceptance of the proposition a fraudster could steal from the bank to repay his own indebtedness and then claim that the bank has suffered no loss as a result of his theft. Such an argument is obviously and demonstrably wrong, as illustrated by the shareholders' own examples. Assume that, in this regard, assume the bank has a non-performing loan to borrower A of £1,000 and that A is an individual entirely and irretrievably unable to pay, so the bank has been provisioned as 100%. On the shareholders' premises, this represents an actual incurred loss to the bank of £1,000. Now assume that A successfully deceives the bank in handing over to him £1,000 in cash, which A uses as he planned all along to settle his original debt. When the bank discovers the fraud and sues him, A's defence is the bank has suffered no loss because it had already lost £1,000 and its loss remains the same after the fraud. That cannot be right. The position would be no different if the fraudster were a different individual, B, who dishonestly obtained the money and passed it to A so that he could repay his debt. And it's 1194 which explains why that can't be right. It's not right as it looks only at the bank's net financial position, ignores the fact the earlier loan has in fact been repaid, and fails to analyse whether the fraudulent conduct in fact caused the loss which the bank is left. The fallacy and sleight of hand is that what is obscured is the fact that when wrongfully obtained money is used to repay the initial loan, the original loan loss is not deferred, it is extinguished. What subsists is the loss caused by the fraud, in other words, the second transaction, not the original lending. This loss, even if in the same amount, is a different loss caused by a different event, and in many cases, as in the example that involves B as well as A, caused by and recoverable from someone else. And he then says that that analysis is supported by Kolomoisky, which you see him then quoting at 1195. And in our submission, the analysis here is this, equally, the problem in this case is the same. The bank is suing on the initial loan. If the initial loan has been repaid, then regardless of how it's been repaid, the loss caused by that initial loan is extinguished and replaced with a different loss caused by a different event. And to treat the loss that the bank is left with at the end of the day on the second or on the two transactions as the same is, as his lordship says, a sleight of hand. You have different losses, different events.
These two cases were concerned with the question whether it was a defence to a claim on the second loan
Yes.
that had been used to repay an earlier fraud.
Yeah.
So that's not the same point. Your point is whether you can sue for loss caused by the first loan when the second loan's been used to repay it.
That's right.
Yes. So it's not actually, they're not actually decisions on the point that for us. It's just you say the analysis leads to the same result.
There are, your lordship, if I said there are decisions on the point, I apologise. I didn't.
No, I'm not suggesting you did. I'm just trying to make clear what these cases actually decide. They decide the liability on the second loan.
They decide that, but it's important. The reasoning, the analysis, but the reason it's actually important is if that analysis in both Mr. Justice Torson and Mr. Justice Bryan is that the reason you can't say that the second transaction was caused to discharge liabilities from the first transaction. Sorry, let me start again. That the premise of the whole discussion is that you have discharged the liabilities on the first transaction. That's the basis of what they're discussing and how it works. Because if you, and that's the analysis, and your lordship sees that. And what I say is that their analysis, in other words, of why use of funds defence doesn't work, the reverse side of the coin is why repayment does work. And that's the premise. I mean, obviously, we have to prove there was a repayment, but on the premise there was a repayment of a debt, then you can no longer sue on that debt, whether it's a restitutionary debt or a contractual debt. Now, there are two other authorities which are not dealing with our type of situation, but in passing deal with something similar. Can I just give you the references, because I need to move on. But there's the case in the Supreme Court called Lowick, Rose and Swinson, which is in the authorities bundle at 31 at page 1007. Now, we don't need to turn it up, but it was a negligence claim against a firm of accountants called HMT, and the claimant, Mr. Swinson, had made 3 loans to a borrower called EMSL, relying on a report by the accountants. So he was claiming that he'd lost money by advancing this money. Now, by the time of the trial, 2 of the loans had been repaid. Sorry, Swinson was accompanied. 2 of the loans had been repaid using money provided by the claimant's shareholder, a Mr. Hunt. And the question was, did the repayments, which had been funded by Mr. Hunt, reduce the loss recoverable from the accountants? Now, the trial judge and the Court of Appeal held that they did not, but the Supreme Court held they did reduce the loss, and the leading judgment was given by Lord Sumption. And if I just ask you at your leisure to look at paragraph 12, essentially he makes the point that if there was a discharge of the loan, then that's a discharge for all purposes. It can't be a discharge between the borrower and Swinson and not treated as a discharge, and so eliminating the loss for the purposes of the claim against the accountants. The transaction, funded by Mr. Hunt, discharged, as he put it, the very liability whose existence represented Swinson's loss. Now, to a similar effect is a case called Tayuta and de Villiers, which is on authorities tab 33 at page 1102, which was in fact cited by Mr. Justice Bryan in Eurov. And I think it's sufficient if I just give you the reference. I've given you the trial bundle reference. It's paragraph 4. Now, what is said in this case about particularly Eurov and Komarchini? It's said by the bank, firstly, that you can distinguish these cases because they involved valid loans, whereas our case involves void loans, and because the loss in those cases was defined in terms of impairment of loans. Now, that isn't a valid distinction. Firstly, if you look at the facts of Eurov, they are more or less identical to our case. The fraudulent loans in Eurov suffered from all the same problems as the loans in this case. They were either void or at least voidable, and the judgment even puts the words loans and borrows in inverted commas to indicate they weren't genuine loans, but it wasn't explored because no one suggested that made any difference. And indeed, you've seen that in order to explain the applicable principles in Eurov, Mr. Justice Bryan used examples based on thefts, paragraph 1193. He saw no difference between a case involving fraudulently obtained loans and one involving thefts, which is how the bank characterizes this case. And the reason it makes no difference is that whether the loan is valid or void, in either case there is an advance of money to the borrower or purported borrower. That gives rise to an obligation to repay, either in contract or in restitution. If in fact the money is repaid, the bank is made whole in respect of the loss caused by the advance, and we suggest no longer has a claim. And there's no reason in principle to distinguish between a valid loan and a contractual repayment on the one hand, and a void loan and a restitution repayment on the other. As to the suggestion that the loss is different in this case, we would suggest that too is wrong. There is no conceptual difference between this case and a case like Yurov in terms of the loss. Now, the bank says now that the true English law position is that a victim can ignore repayments of earlier loans, just as it says is possible in Ukrainian law. That's its skeleton at 87. Now, I've shown your lordship Kolomoisky and Yurov, where the position has been considered. The bank doesn't cite any authority the other way, apart from paragraphs 1148 to 1153 of the judgment below. But that part of the judgment is addressing a different question. It has nothing to do with the repayment, whether the repayment of a drawdown extinguishes the loss arising from that drawdown. That's part of the judgment where the judge was addressing the use of funds defense, and specifically the bank's argument that the use of funds defense didn't work because the defendants would need to show that the wider loan recycling scheme had actually benefited the bank overall, which they hadn't sought to do. Now, can I turn to my next point, which is the Ukrainian law evidence, having looked at that. Now, can we start by looking at Mr. Bektov's written evidence? And if you could go to the supplementary bundle. At page 9, this is an extract from Mr. Bektov's main trial report. And at paragraph 128 on page 9, he is addressing, you can see the heading is "Monies advanced by the bank under the relevant loans were themselves used purportedly to repay earlier loans advanced by the bank." So here he's addressing the use of funds defense. So, and what he explains is that
this is his report for trial.
This is a report for trial, my lord. So you can see in 128, he's talking about funds. A particular borrower receives as part of a misappropriation being circulated back to discharge earlier loans. He says the unlawful actions would remain actionable and the repayment would not reduce the amount of loss caused by the misappropriation. And at 129, he explains that the victim of a tort is entitled to full compensation. And in the posited scenario, the liability in contract under the earlier loans and the tort fees as liability for the subsequent misappropriation are separate and distinct. Liability in tort for the theft disguised by a sham loan is not remedied by using those funds to pay off another separate liability in contract. Because in my opinion, that wouldn't result in the victim of the theft being compensated for the loss caused by the later tortious act. Now, if you go to 135, or at 134, he says he hasn't found any Ukrainian court judgments on the point involving analogous facts. So he bases his conclusion on first principles, in particular the principle of full compensation and justice, reasonableness and fairness. And then he says in 135, in the absence of relevant case law, he's been asked to consider and comment upon paragraphs 1186, he says, and 1196, it obviously means 1186 to 1196. Of the judgment in Euro. And those are the passages where this point was being considered that I showed you. And he says that in those paragraphs the English court was seeking to interpret Russian law. Then he points out what the court had concluded at 1193, and he says at the foot of the paragraph that it accords with his own conclusions on the basis of relevant Ukrainian law principles. So for the foregoing reasons, I consider the monies advanced under the relevant loans were themselves used purportedly to repay earlier loans. This would make no difference to the bank's tort claim as regarding the quantum of loss the bank can claim caused by the misappropriation.
You said this. Is this the use of funds?
It is. This is use of funds.
This is not the.
No. This is the use of funds defence.
Yes.
And because in the next section he's then dealing with the repayment. So you see the next heading. A number of purported cash repayments of the capital advanced under the relevant loans were made from funds advanced by the bank under other relevant loans or intermediary loans or new loans, all of which were void on grounds of being contrary to public order, shams, related party lending on preferential terms or other unauthorised significant transactions. So this is repayment, as we're calling it. And again, he says he hasn't found any Ukrainian cases, but for the reasons given below, I consider that where monies purportedly used to repay an unlawful loan are themselves referable to other unlawful lending, then the purported repayment on loan one would not operate to reduce the lender's loss caused by loan one, for which the lender would remain entitled to be fully compensated. Now, the first reason he gives for this, so that's, your lordships will see there that is exactly the same as we saw in his pre-trial report at the interlocutory stage. Now he explains it at 138 that if the loans are void, they don't, a void transaction is void ab initio, and what he's looking at is loan 2 being void, so that a Ukrainian court would not uphold its purported effect in discharging or reducing the liability in tort arising from loan 1. So this is all a consequence here of loan 2 being void. There's no suggestion in this report that it makes any difference whether the relevant loans are void. So he simply has put his proposition on the basis that you have an unlawful loan, which is loan 1. In other words, it doesn't matter whether it's void or valid. The reason it's important to bear that in mind, you'll see he does a complete about turn in his cross-examination on that point. Now, the reason, in fact, this is a bad point and is one that is not pursued is that the fact that loan 2 is void doesn't mean, as we have seen and will see again, that the borrower under loan 2 hasn't received the money and received the credit, which it can do with as it pleases. And if the credit is used by the borrower to repay, that repayment isn't void or of no effect. And that part of his reasoning, for the purposes of the litigation, seems to have fallen away. And at paragraph 139, he makes a different point, which is that he says that it's a sort of statement of principle that where a tortfeasor causes harm, he can't be allowed to eliminate the harm by stealing money from the victim at a later date then returning it to the victim in purported compensation for the earlier tort. Whilst perhaps unsurprisingly I have not found any case law on this point, I'm confident a Ukrainian court would reject any such suggestion. It would create a perverse incentive for the tortfeasor, who could, for example, eliminate a liability for a discovered tort by committing a further tort that might not be discovered, and in my view would be contrary to principles of justice, reasonableness, and fairness. Now, of course, the first thing to note is that in this analysis, he fails to reflect on what he has seen in the Yurov case, which he's already said represents Ukrainian law. The next point is that what he is saying here is, we would suggest, is really assertion. It's a sort of unsupported ipsi dixit, which the Supreme Court said is irrelevant and inadmissible in Kennedy and Cordia, which is at page 847 of the authorities, and it's at paragraph 48. Or, at best, it's purely a point of principle and not based upon any specific knowledge or experience of Ukrainian law. Now, in our submission, it is in any event this incentive point nonsensical on its own terms. The only reason put forward is that the tortfeasor might eliminate liability for one tort by committing another, but the argument that the claimant should be entitled to choose which tort to sue on presupposes the claimant knows about both. But in any event, we say it doesn't really make any sense. But then at 140, he puts forward a further point, which is if the court were to approach the quantification of the loss caused to the bank in this scenario by assessing the loss caused by each of the independent tortious acts represented by Loan 1 and Loan 2, respectively, then I would consider such loss to be for each tort the amount of that loan less any genuine compensation received in relation to that tortious loss, together with any damages recoverable under Article 22, such as interest and opportunity cost. There's no rule of Ukrainian law that would oblige the victim in such circumstances to sue the wrongdoer in relation to one instance of misappropriation rather than the other. He could choose which instance to sue on. Now, again, we're going to show you in a moment how this developed in cross-examination, but this was pure assertion. Now, if we could just look very briefly, just to see, so you see how this all developed. If we go to page 17 in the supplementary bundle, we have the joint statement. And at paragraph 45, in the joint statement, you can see they disagreed, the two experts disagreed as to whether it makes any difference to the bank's claim if the funds received by a particular borrower were circulated back to repay earlier loans. And 45.1 reflects what we've seen, Mr. Beketov's view, an application of first principles, and apply it consistent with Yurov. He explains why you reject the use of funds defense. And then at 46, he deals with the repayment defense and simply repeats his earlier view. Now, what's important, again, at this stage, he hasn't said whether his view is affected by whether the original loans are void or valid. That doesn't form part of the reasoning. Now, when you go to his supplemental report at page 39, paragraph 200, he here says that at A, he explains that Mr. Alyoshin, the defendant's expert, or Mr. Kolomoisky's expert, has proceeded on an incorrect basis, as he assumes the relevant loans are lawful and created valid contractual repayment obligations. But he says it's necessary to assume the bank's claim is made out. And so at 1, he says the purported repayment of the relevant loans using funds derived from the intermediary new loans did not discharge any contractual repayment, because if the relevant loans are void, then they created no contractual obligations which could be discharged. So at this stage, he's saying, well, because they're not contractual payments, then there was no discharge. But then he says, even if at B, the relevant loans are not void, but were the product of the defendant's unlawful and tortious conduct, including if they were the product of an abuse of right, in summary, in this scenario, there would be an earlier misappropriation and a later misappropriation, both of which involved unlawful and tortious conduct, and both of which caused loss in the amount of the funds misappropriated, less any genuine recovery. In that scenario, the victim could sue in respect of either misappropriation, but could not be permitted to recover in respect of both. So what we see as the evidence, the written evidence developed, is that originally Mr. Beketov had based his view on the later loans being void. Now he's saying it's significant that the relevant loans are void, but he says the significance of that is that you couldn't be discharging any contractual repayment. He doesn't actually consider the restitutionary position and whether or not discharge of the restitutionary obligation would have an effect. But then he says, well, anyway, doesn't matter, even if they were valid loans and there were valid contractual repayments, still makes no difference to the tortious loss. Now, can we then go to the extract from his cross-examination, which you have at page 111 on day of the bundle. This is day 27 of the trial. And if I can use the transcript page references, see at page 99, line 11, I said that I was going to move to repayment and use of funds. And then at line 21, I said to him, what I want to ask you some questions about is the situation where an unlawfully obtained loan, so here looking at the relevant drawdowns, is repaid using the proceeds of a later loan, okay? Now I want you to assume for these purposes that both the original loan and the later loan are issued as a result of some unlawful conduct by a particular person, which could in principle give rise to a tort claim. In other words, I've made it clear both loans have been procured by someone who will be liable in tort. So at 7, the question I'm interested in at this stage, Mr. Beketov, is whether the lender has a claim in tort in relation to the first loan, which has been repaid using the proceeds of the later loan, or whether there is in fact no claim because repayment of the first loan means that the loss that arose when the first loan was drawn down has been extinguished. Okay. Then he asked for clarity on the source of the funds that were used to repay the first loan. He was concerned to know whether the first loan had been repaid with money from the claimant's own sources. You see that in the exchange at 14 to 18, and at line 22 to 23, he says, yes, but you know that money under the first loan were repaid from the claimant's own sources. And I confirmed that was the case at the foot of page 100. And I said, it's very simple at line 24. The hypothesis is you have a first loan said to be unlawful, a second loan said to be unlawful, and the proceeds are used to repay the first. And he says he confirms he understands that. So, my lords, right from the outset, the basis for the questions is clear, and the suggestion that some of his answers, which were unhelpful to the bank, somehow lost sight of that fundamental premise is, we would suggest, totally unsustainable. Now, I took him at page 102 I'd taken him to the joint statement, and I asked him about the principles that were in play, and at page 102 at line 12, he said the first principle was Article 15, which is the general principle that a person whose rights are violated is entitled to have a claim for protection of his rights. Then I asked him whether there were any other principles, and he said, you see on page 103, he refers to the principles of reasonableness, justice and fairness, and Article 1192 at line 7, which provides for full compensation. And then at 103 line 10, I sought to see what he was saying. So I said, let me just see if I understand this. Where the loans, the first loan is unlawful and has given rise to a claim in tort and is repaid by a second loan, which is also unlawful, you say that these first principles apply so that the repayment out of the proceeds of the second loan do not serve to reduce the loss in tort suffered by reason of the first loan, correct? And he says these principles apply to the right of the claimant to sue on whatever tort he considers appropriate. So I then asked him at page 104 at line 14 whether it made any difference whether the loans were void. Said, next thing I want to get clear, whether or not the loans are void doesn't matter, does it? Sufficient for your analysis that each of the loans was granted in circumstances which were unlawful and so gave rise to a claim in tort. Correct? And he said correct. So there, at this stage in his cross-examination, he's reaffirming what I showed you a moment ago in his supplemental report, that the distinction between valid and void loans is irrelevant. And he's got this broad principle of Ukrainian law that essentially, for the purposes of the tort claim, allows the claimant to sue on whichever transaction he wants. So having said that, I said at the foot of the page, what I wanted to test this by looking at first the basis that loans were valid. And if you go forward to page 112.2, and if we pick it up at line 20, in a situation, second sentence, in a situation where there is a loan, a valid loan, that has been repaid.
Sorry, which page of the transcript?
It's on the transcript, it's page 109. at line 20. The line begins, let's come back to that if we need to. In a situation where there is a loan, a valid loan that has been repaid, you accept in that situation the borrower has no more liability, although you say there is still a loss for which the bank can recover by way of a claim in tort, correct? So I'm testing, you can see the question, that the repayment discharges the debt but you say of a valid loan, but you say that the bank can still sue in tort. And he says, yes, because in such situation, contractual obligation extinguished, a new obligation is in tort when restitution appears. And I said, no, I think you're misunderstanding. And you have a loan to a borrower. Yes, he says. That loan is repaid out of a subsequent loan, which is both are wrongful. As I understand it, you accept that the borrower is discharged when repayment is made in respect of his debt, correct? If early borrower was debt was under valid loan, yes. But, you say, even though the borrower's debt has been repaid, do you say that the bank can still go against the wrongdoers who arranged the loan, the wrongful first loan, in claim in tort, or is that claim now extinguished? No, he says. Under proposition that early loan and new loan are void, it is possible. On the proposition if the early loan is valid and if later loan is void, then the claim may be made only in respect of the later loan, which is void. Right, I think we're getting confused. Let's just get clear now what your evidence is. The first loan is valid but wrongful. Okay. Repaid out of a second loan, which is also wrongful. Now, taking the first loan, if that was a valid loan and a payment is made in respect of the borrower's liability, as I understand it, you say the borrower's liability is extinguished, correct? Yes. And you also say because the borrower's liability is extinguished, in other words, he has repaid his money, then the wrongdoers who arranged the loan to that borrower, they also have extinguished their liability because the borrower's liability has been extinguished. And so there is no further loss the bank suffers. Is that right? I think on the propositions that the first loan is valid, it is right. Then he makes a comment, which we may have to come back to, where he says, under Ukrainian law, we don't have wrong or imprudent debts. We only have valid or void contractual obligations. And then he confirmed in the exchange that takes place on page 11, 111 from line 19 through to the next page at line 17, he confirmed that where you have a valid loan, even if it's wrongfully been procured, and that is repaid out of the proceeds of an improperly obtained second loan, that is both goes to discharge the debt of the first borrower and to extinguish the loss of the person who procured it. Now, your lordships, I trust, can see that this is a fairly remarkable volte-face, both from what he had said in his report and what he'd actually said just a few moments earlier, a few pages earlier in the transcript. Because the principle of Ukrainian law that he was putting forward, as you've seen, at paragraph 137 of his 8th report, supplementary bundle at page 11, that where money is purportedly used to repay an unlawful loan are themselves referable to other unlawful lending, then the purported repayment of loan 1 would not operate to reduce the lender's loss caused by loan 1, and the lender would remain entitled to be fully compensated. In his 9th report, he said it made no difference if the relevant loan was valid or void, and in his oral evidence up to this point, he'd made the same point. But at this point, he throws all of that out of the window. He expressly agrees that if the loans are valid, the earlier loan is valid, there's no choice at all. The repayment repays the indebtedness and extinguishes the loss. Now, the judge recognized that this was this was his evidence. If I can show you that, he doesn't. The judge doesn't reflect on the significance of this, but if you go to the judgment at paragraph 1059. And that was page 394 of the judgment. And what you see is that at 1059, the judge refers to my cross-examination and says I put to him a number of hypotheses based on whether each of the first loan and the later loan used to repay the loan was valid but unlawful or void. In closing argument, it was submitted that Mr. Beketov's answers in cross-examination established that if the relevant loans were valid and they were repaid by the proceeds of later valid lending, each borrower's liability to repay a relevant drawdown was discharged, and any third party's tortious liability for procuring the relevant drawdown was extinguished. I agree that in that situation, Mr. Beketov's answers in cross-examination were that there was no distinction to be drawn between the effect of the repayment on the borrower's contractual liability under the relevant loan and its effect on the harm caused by the loss of the proceeds of the relevant drawdown, which would otherwise be recoverable in tort. Both are extinguished. However, the evidence that Mr. Beketov gave orally was not explicitly qualified in the way he had expressed matters in his reports. In his reports, he had said that where there were two unlawful but valid loans, both caused by the unlawful conduct of a third party, the latter of which was used to repay the former, the lending bank could choose to sue in respect of either, so long as it did not make a double recovery. He'd also said there needed to be a genuine recovery by the victim, not sourced from his own resources, for the tortious loss in respect of loan 1 to be extinguished. Now, just pausing there for a moment, what you see is, I've shown you what the expert's report said. And the whole premise of it was we've got this principle in Ukrainian law, and it makes no difference whether the loan, the relevant loan, is void or valid. The principle is that if it was procured tortiously, then, and you tortiously procure some further money which you use to repay the first loan, then the principle of Ukrainian law is the victim can essentially ignore the repayment for the purposes of his claim in tort. Now, the judge at 1059 to 1060 recognizes that the witness, the expert who's putting forward this theory of Ukrainian law, has thrown out a large part of the thesis. When cross-examined on it, he said, no, well, you've seen it. You've seen where we got to. So, the judge, because he places such reliance on his interpretation of what Mr. Beketov says about void loans, totally fails to engage with the fact that a critical part of his evidence has just been abandoned. Now, we can put away the judgment and then go back to how things developed. So that part of the cross-examination, as it were, on the legal principle, it entirely resulted in an abandonment of Mr. Beketov's evidence insofar as you were dealing with valid loans. Now, the next day, we came back to it, and that you can pick it up in the supplemental bundle at 113.1. On day, this is now day 28, and at the bottom of page 16, I said at line 22, I want to come back to an issue we were looking at yesterday, and I broke off it from because I wanted to review your evidence overnight. So I'm going back to the question of repayment. So over the page 17, I said, you'll remember yesterday we were discussing the situation where an unlawfully obtained loan is repaid using the proceeds of another unlawfully obtained loan. He said yes. Then I reminded him of some of the evidence, what he had agreed at lines 14 to 17. So I said at 14 we've agreed the loan being repaid was valid. Repayment of that loan extinguishes the liability of the borrower, correct. And then in the following bit, line 20, reminded him that he had agreed that the tortious liability is eliminated, tortious loss is extinguished, and at page 18 at line 4, again, well, at line 4, the reason one has to see this is because there were times when he seeks to go back on his evidence, but eventually you'll see he stood by it. So at line 4, so what we also agree is that if the borrower's liability in respect of a valid loan is repaid and extinguished, then any liability of third parties in tort in relation to that loan is extinguished. And he said, I took it not as liability of third parties, I took it as saw it as liability of borrower, particularly counterparty, because as I said, that liability would be extinguished also, because the liability would extinguish also because such counterparty to valid loan would not be able to make a tort claim. Now, he then, I said, wait a minute, and went back through it, and you see at the top of the next page, he confirmed what he had said the previous day. You see it at the very top of page 19, or bottom of page 18. I think in that respect it may be agreed that, you know, there was no further loss that the bank suffered. And in this respect, yes, even though the bank would have ability to file a tort claim against third parties, their liability would be extinguished by repayment of the valid loan. And so we then, or then again, I made it clear that, so you see on page 19 at line 5, now we have a very clear position where there is payment made in respect of a valid loan. We've had a debate whether the loans are valid or not. We don't need to go over that. What I want to ask you about is the separate position in the event the loans were void, loans being repaid, or the loan being repaid is void. I think the reason I just stress this, the basis of the whole discussion is, and the whole premise of the need to cross-examine, was a situation where one loan is repaid using another loan from the same borrower, another unlawful loan. And that's the premise of every single question that has been asked. from the same lender, sorry. Now, the first thing that we established on page, if we go to page 114, at page 21, at lines 19 to page 22, page 11, I don't need to read it out, we established that where you have a void loan, the borrower or the recipient has an obligation, not in contract but in restitution, to repay the money. So, and that's obviously the case, and there's no dispute about it. But we then, on page 22, at line 5, had this exchange. If you ignore the first line, if the borrower makes restitution under Article 216, that's the article that creates the obligation to make restitution, leaving aside a case where there might be a claim for some additional damage, if you pay back the money, then the borrower's liability to make restitution is extinguished, isn't it? In a narrow sense, he says, if we're dealing only with void transactions and obligations between Party A and Party B to this transaction under Ukrainian law, as a matter of principle, it is extinguished. And I said to him, yeah, that any other answer would be ridiculous. If I take money from you improperly, I take $1 million, I'm liable to return it in restitution. If I give it back to you, then my liability will be extinguished. And he says, as I said, in this narrow specific case, yes. Well, in any case, if I return the money I took from you, my liability to return it is extinguished, yes or no? It is extinguished. He says, yes. So that's the first thing. So if one remembers, in a case of a valid loan, where you repay, the borrower's liability is extinguished. In the case of a void loan, where you repay, the restitutionary obligation of the person who drew down the money is extinguished. So I then asked him, at the foot of the page at line 25, foot of page 22, if the borrower's liability in respect of the loan is extinguished, his liability in restitution, then any loss which the bank has suffered by reason of the taking of the money in respect to which has received restitution will also, as a result of the restitution, be extinguished, won't it? Now, he then says, no, Mr. Howard, I don't agree with you on this. So I then said, at line 9, Mr. Hunter helps me steal $1 million from you. I'm liable in restitution. Mr. Hunter, he would never do this, but he's just to my left. That's why I'm using him. Mr. Hunter is liable in tort. I give you back $1 million. You agree my liability in restitution has been extinguished. We've already discussed that. Yes. Your loss as a result of my having taken the money has also been extinguished, hasn't it? Now, no, because concept of loans under and that must be loss, under Article 22 of the Civil Code, is wider than restitution. Now, this is an important answer. So, because by this stage in his cross-examination, he's ditched the thesis that he had put forward in his report concerning repayment. And now he's trying to come up with another argument why repayment of restitutionary obligations arising out of a relevant loan which was void doesn't extinguish the claim in tort. And so what he starts to talk about by reference to Article 22 is that the loss can be wider than simply the amount of money drawn down. And so I then asked him, well, what loss? Where I've given you back your $1 million, what loss have you suffered? Well, we talk about it, I believe, some hypothetical way, he says. But if you look at Article 22, it has 3 counts of loss. And so what he then does, I don't need to read that out, he talks about that you might have 3 heads of loss. One is for The money, one might be, a further one might be for expense, and I think it's also potentially for some sort of loss of profit. So, self-evidently, if you did have a claim that was wider than the money that was simply taken, one can see repayment of the money wouldn't extinguish that further loss. And so I then, at line 13, put to him, at line 12, okay, that's fine, all very good. So insofar as you haven't suffered a loss of profit and you haven't incurred expenses, let's leave that on one side for the moment. Your only loss is I took $1 million from you and now you have $1 million back. In that situation, there would be the liability in restitution has been discharged, and the claim in tort against Mr. Hunter who procured this would also be extinguished because you would have no further loss you could claim against Mr. Hunter, correct? The claim would not be extinguished, but the loss under the claim may be extinguished. Not maybe, I said, would be. And he agreed, would be. So what you have there is the argument that he first came up with, namely that there might be additional losses beyond deprivation of money, didn't assist the bank's case. And in fact, the point he was making would equally apply to a valid loan. Now, if things had rested there, it would have been game over, you might say, at least on the point of principle, because there was clear and unequivocal acceptance by Mr. Beketov that the tortious loss would be extinguished in the event of a void loan being repaid, just as he agreed it would be if a valid loan was repaid. And you'll note that in the judgment at 1062, the judge refers to this exchange and indeed notes that it was as I have just described. So 1062, page 394. Mr. Beketov was asked about the impact of this restitution on the bank's claim in tort against a third party who procured the original transfer. Initially, he explained correctly the tortious harm may exceed the amount of the restored transfer because, e.g., the transferor may have sustained a loss of profit or incurred expense. However, when he was asked to leave aside those types of harm, he accepted that the claim would not be extinguished, but the loss under the claim would be. This appeared to be an unqualified answer and as such seemed to be inconsistent with the position espoused by Mr. Beketov and summarised by the evidence he gave in paragraph 46.1 of the joint statement. Now, just stopping there for a moment, everything he said about valid loans was inconsistent with his written evidence and what he had said in the joint statement. And the judge was right that what he was saying here was similarly inconsistent. But the nature of these things is such that it then developed. And at page 115 of the supplementary bundle, page 25, I sought to summarize the position. So at line 8, I said, so I think where we get to, the position actually of whether that loan is being repaid is valid or void is actually the same. The question is, or if there is in fact repayment of the loan. If it's a valid loan or restitution of the money is taken, the bank's loss in respect of the taking of the money is pursuant to the loan, whether valid or void would be extinguished. And so any liability or any loss that could be claimed against the tortfeasor will also be correspondingly extinguished. It would be right, he said, if again this extinguishing took place with not, I would say, victims' own resources. Now, it's important to stop there for a moment and just reflect on how this point came about. The question was whether the loan was valid or not. Would a repayment of the loan amount extinguish the liability of the borrower, whether in contract or in restitution, and so extinguish the liability of the tortfeasor? Now, we've already seen that Mr. Beketov agreed the position in respect of a valid loan. Then, when we started talking about void loans, he had sought to wriggle by putting forward his thesis of different types of loss, but then had given up on that. And you will also recall that the questions the previous day, and the whole point of all of this, the whole debate between the parties, was that the repayment was sourced from sums drawn down under second wrongful or unlawful loans. So what you had here in this answer by Mr. Beketov, where he says, well, not if it was sourced, as he put it, from the victim's own resources, that he was going back on the point that had been agreed the previous day, or seeking to qualify his answers by saying he had not meant there would be extinguishment of the loss if the repayment was sourced out of the victim's own resources. So, I mean, this was a major a further volte-face, because here he was giving this answer both by reference to valid and void loans. Now, you can see at page 25, at line 20, I pointed out to him that all of these, the whole of the questions, every single question has been based upon the source of repayment being another unlawful loan from the bank. Every single question has been on that basis, and I've made that clear. The witness then said, but in your proposed scenario, actually, you did not. When you put those questions about discharge by restitution of loss, actually, you did not say that this is because monies were taken from the victim of tort to do so. I said that I had, and the transcript would show that, and he said at line 9, I should put on record that my answers to these questions were in relation to the scenario where the money repaid in restitution were taken from proper sources, but not from the victim's own sources. Now, the oddity about this, if you just think for a moment, is he's trying to say that there's a Ukrainian law principle which applies to a repayment of a restitutionary obligation, but as you'll see, he doesn't say the same principle applies where it's repayment of a contractual obligation. And so one can see that this is all further muddled. Now, the judge at this stage intervened, and you see that at page 26 at line 16, saying I needed to challenge the witness. And so I did, and I took him to the transcript and read out where we had agreed the basis of the questions. And then at page 27, at line 17, again, this is important, and I would suggest the judge entirely ignores all of this. At line 17, I said, Mr. Beketov, that is clear, isn't it? That what I was telling you we had been discussing You can see it on the previous day's transcript if need be. But what I reminded you of this morning, we were discussing the situation where an unlawfully obtained loan is repaid using the proceeds of another unlawfully obtained loan. That's what I was asking you about, correct? And he agreed. And on the next page, I put to him at page 28, line 14, your evidence unequivocally was given in the context of a payment of the earlier loan being made by use of a subsequent loan, which was wrongful. That's right, isn't it? It was, he said, but then he sought to wriggle it out by saying, you know, some questions you put to me, I should say, were on a narrow proposition, and I repeated several times in a narrow sense. I took it we're not discussing the situation of where discharge of restitutional obligation under the loan 1 was via money obtained under fraudulent loan 2, as you put it with Mr. Hunter. I thought this situation was actually money obtained from other source, and I thought it was a matter of principle. And as a matter of principle, if you can repay money from another source, and this is only damage which you suffer, I mean victims suffer with those monies, then these were right answers. But you know, a very different answer would be if money came from victims' own resources. With respect, that was totally incredible as an explanation. He couldn't have understood and didn't understand the basis for the questions had somehow changed. And to ask about the effect of repayments using money from a different source would have been pointless and irrelevant. There was never any dispute that repayments not derived from the bank's resources would extinguish the loss. The issue in the case had only been about the effect of repayments using further wrongfully obtained loans from the bank. Anyway, we went over the ground again, and I'll just give you the references. On page 29, line 8 to page 30, line 5, which is all on page 116, and page 33, lines 11 to 18, he reconfirmed his evidence given the previous day relating to valid loans. So in other words, if the loan is valid, it doesn't matter on his evidence. And the thing that makes it important is that it is void. And at page 116.1, what happened at page 35, at line 19, when I was going back through this, Mr. Hunter intervened and made what I would suggest was a wholly inappropriate intervention. As you see, what Mr. Hunter said was, just as my learned friend goes through this, so he has the point and we don't miss it. The issue that needs to be grappled with is when we move to this sequence of questions about theft, including the example involving me, if you read the transcript beginning at line whatever it is, there's no reference to where the money's repayments are coming from. That's the lack of clarity. So, and I said I didn't accept. But the judge then said, it's important that we get what Mr. Bektov's evidence is now. So, and we then, at the foot of page 36, going over to page 37, you have some questions which go to the heart of this. So at 116.1, at line 19, or line 20, as a matter of principle, that's why it's important to remind you and to ground ourselves in what has happened, what we've agreed so far unequivocally, just so we have it, so we can see how things work. a loan, loan A, is improperly arranged by a defendant, an official of the bank, and the loan goes to a borrower. You agree that assuming it's a valid loan, if repayment is made via drawdown under another wrongful loan, that's what we agreed yesterday, then the repayment, the money that comes into the borrower's loan account, that discharges the borrower's liability and also eliminates or extinguishes the loss that the bank suffered by reason of having provided the loan in the first place. Correct? Yes, correct, Mr. Howard. But I would kindly be asking you, if you're making these propositions to me, please refer to the source of repayment because it's very important. And I said I have done, and at line 17, I said there was a limit to how many times we could go back. And I asked him to confirm his evidence, which he'd reviewed overnight. So then at page 38, at line 23, and there's a fairly lengthy passage that follows, at line 23, I say, let's assume that. Let's see if I can understand your position. If I can just try and break it down. We're dealing with two void loans. So you have void loan, calling them loans, but they're void. But it's easier to call it loan. So you've got loan A for $1 million and loan B for $1 million. Now payment to the bank of $1 million, so two lots of $1 million have gone out, $1 million comes back. Now is this how I should understand your evidence? The bank is entitled to choose whether to treat that $1 million that has come back as repaying the restitutionary liability that arose in respect of loan A or the restitutionary liability that arose in respect of loan B. Yes. It's for the bank to make the choice. Yes. Now just stopping there for a moment. That's simply reflecting what the position would be in English law in restitution, in that if you had somebody had two restitutionary obligations to a bank, let's say each one is $1 million, and they turn up and say to the bank, here's $1 million. The bank, even if they say it's for loan one, the bank can choose whether it credits it to loan one or loan two. And what he's saying is the bank can choose which transaction it credits to. So then on page 39 at line 15, now assume that the tortfeasor in my example comes along and says, here is $1 million, and I'm paying off the liability in respect of loan A. So he says that, assume the bank says, thank you very much, Mr. Tortfeasor, and credits the receipt to loan A, and treats itself as having received full restitution in respect of loan A. Okay. He says, okay. Now, if that happens as a matter of fact, the bank says, thank you, I'll take that $1 million and I'm crediting it against loan A. Having done that, if the bank does that at that stage, having credited loan A, do you agree that the bank would no longer have any outstanding claim in restitution in respect of loan A because it's received $1 million and it's credited to loan A? If, as a matter of fact, as you said, this would be the position of, let's say, hypothetical bank, have to treat repayment of this liability, I would say it may be, again, as a matter of fact, that in this case, the bank made a decision how to discharge this liability. Yes, great. I think that's very helpful. That's what I thought, and we're largely agreed. So in this scenario, the bank having said, thank you, I'll take this money for loan A, it still has its cause of action pursuant to Article 216 and in tort relating to loan B, correct? Yes, because it still suffers the loss. But on loan A, if the bank does this, if it says, yes, I'm taking the money and applying it to loan A, in that situation, it no longer has any rights to restitution in respect of loan A because it's recovered the restitution, would no longer have any claim in tort for procuring loan A because it doesn't any longer have a loss in respect of loan A, correct? Now, he then gave this answer. Again, Mr. Howard, if I may be taken as a true fact, that in such a way the bank decided that it has to be compensated. In other words, that the bank is fined that it's repaid with its own money for this tort. And there is evidence that in fact happened. There was the will of the bank to do so, then I believe any lender in such situation would have difficulty to claim this loss. I'm saying the bank would have difficulty to claim such loss. Now, the judge then said that the problem with the answer was it was rolling up restitution and tort. And so I said, let's break it out at line 17. Once the bank were looking at a hypothetical, but it's a factual question, but on a hypothetical factual situation, the bank takes 1 million from Mr. Tortfeasor. Thank you very much. Credit it to loan A. In that situation, the right to any restitution has been extinguished in respect of loan A. In restitution, yes. So stopping there, his evidence plainly was that a repayment of money drawn down under a wide loan, sourced from a later loan, and so from the victim's own resources, would extinguish any liability in restitution if the bank took the money and credited it to loan A. But then we went on at page 42, line 1, and insofar as there is a claim in tort against anyone who procured loan A, at least insofar as, well, insofar as the bank's damage is the loss of the money, because it's received the money back and it has accepted the money as in respect of loan A, the bank no longer has any tortious loss to claim against the tortfeasor. If the claim in tort would only be in respect of money which was taken from the bank under the loan, as I said, you know, the concept of loss under Ukrainian law is wider than the concept of debt. So we have 3 items of loss. But if the bank only claims 1 item, from what you're saying, thinks of what he has been deprived of, not loss of profits, not expense, then, and it is, as I said, is the way the bank decides it should be remedied, then it's hard to say as a matter of fact that the bank was not remedied in restitution. And I said, well, I think we got confused. The purpose of the question, and he said, yeah, okay, it was limited in tort, yes, yes in tort. So, now, the evidence, that is the critical bit of the evidence that the judge has relied on, because the judge has interpreted Mr. Beketov in this exchange as saying that it was necessary for the bank to, in accepting the money, to both treat it as a repayment of the restitutionary obligation and to waive its right in tort. Now, it is fair to say, well, particularly now your lordships have seen the evolution of Mr. Beketov's evidence, it is fair to say that the evidence at best was somewhat confused, and but the way in which it evolved, what it does show is that the principle that he was enunciating had no firm or any foundations in Ukrainian law. You have to look at where he started to where he ended up with this, at best, equivocal position. Now, I'm not going to go through it. My learned friend sought to re-examine. You have the re-examination in the bundle at pages 118.2 to 4. The judge didn't refer to it, and you'll see there are a series of leading questions put, and in my submission, what the evidence obtained there was worthless, and that's no doubt why the judge also doesn't refer to it. But what I've shown you, I'll obviously come on now to make some submissions on this. This is the totality of the evidence on the bank's side on the repayment defence. So your lordships, this is a case where your lordships have seen both his written evidence, the written evidence of Mr. Beketov. I haven't shown you our evidence, but you've seen the written evidence of Mr. Beketov, and you've seen the cross-examination, and you've seen how it developed. And after the short adjournment, I'm going to go on to briefly consider the principles of, that apply in this court when considering an appeal that concerns foreign law. But your lordship can see the context in which we're considering it, and both the narrow compass of the evidence and how what we're dealing with are essentially an assertion from an expert which is not based upon any underlying principles, or at least most very generalized principles, and said to have been analogous with two cases, or the Yurov case, which also then must mean he's saying with the Kolomoisky case. And so I'll come back to that. But in our submission, this provided Mr. Beketov's final position that he got to provides a very unsatisfactory basis for the judge's finding.
Very good. We'll resume at 2 o'clock.
Right, able.